she loves me. Isn't it lovely when the one you love's thing is the one you're loving?
I'm not sure that going to an elite university is the path to prosperity. It is actually going as high as your character, your grit, and your talent will take you. That means whether you go to Harvard, Charleston Southern, or whether you want to be a plumber or a welder, you too can experience your version of the American dream. I'm running for president because I know America can do for anyone what she has done for me.
That was Tim Scott. And like Dr. Carr said, that broken clock can be right twice. It can be. He is a broken ass clock, as is Clarence Thomas. Sina Ghaznavi is here, and joining us is one of the greatest legal minds of this time. She is the only law professor teaching law through an Africana lens. She actually created a whole curriculum, which she is teaching at American University. Right. And let me welcome the great, the one and only Angie Marissa Porter is here. Hi.
Oh, thank you, Karen. That's so kind, far too kind, but I receive it.
Yeah, because it's true. And I feel our mom, whose son is at Stanford, and her mourning and her loss. Because she in her spirit, she's feeling like the opportunities that her son will benefit from, the next generation will not. But I'm like, let's create new ones. Let's create new ones. As someone who went to Howard Law, as did Thurgood Marshall, who was the first Black person to sit on the Supreme Court.
Right.
She makes a point, though, about today when they're looking at clerks, which is usually the pathway. Ketanji Brown Jackson was a clerk for Souter, I think, went to Harvard, was in that. Barack Obama, the first Black president, was a Harvard Law Review editor. So was his wife, was at Harvard and Harvard Law. So there is that networking.
Yeah.
Is that going to be hampered?
Yeah, well, yeah, and I think Justice Jackson clerked for Breyer. She clerked for
Breyer.
Yeah, because she replaced
right.
Breyer. Yeah.
You're right.
No, I'm so glad you raised that, because I'll just say, I stay mad. My heart rate didn't even go up because I'm already mad all the time. I'm like the Incredible Hulk in the Avengers, I stay mad. But the reason I'm mad is not the crying, sighing, dying, oh, woe are us, we can't go to Harvard anymore. It is that this is part of a long-standing concerted effort to attack our people. It's another battle in the attack. And that is the enraging part, because this is not just about race-conscious admissions in higher education. This is about colorblind constitutionalism. And we could talk about what that means, but this is a win for the larger strategy of the attack, the assault on Black people that has been longstanding since the 14th Amendment was passed. And it flows to other non-white people. So this is a tragedy of epic proportion when it comes to the battle that we're fighting. But I agree with you, Karen. Like, I went to the HBCU. Now is the time for us to support the institutions that have supported us all along. And we used to get upset when people would call Howard the Black Harvard. I mean, some people get off on that, but never me and never many, because we are not trying to emulate Harvard. Again, that's not everybody. Some people fancy that as a legitimate goal, but Howard, Hampton, other HBCUs, NCCU, FAMU, the HBCUs that have law schools, we are doing our own thing, and we are innovators, and we're thinking on a wavelength that is honoring our experience as African people in this country who have had to push up against the law from its inception in the United States, from the time it was a collection of colonies. So yeah, that prospect that there will be now more people seriously interested in the HBCU and in the HBCU grad schools and professional schools. I mean, that's what we need to be doing anyway. But this is an assault on our people, telling us you can't go here and trying to drag us back. I think Mike Pence said something like, this is a great step back toward an America where you're not judged by the race, your race, but the content of your character. The man said a great step back. And by that, he meant exactly what it sounds like he meant.
So let's
this
take
is
us
part
back.
of that. Yeah.
Take us to school, Angie Marissa Porter. 14th Amendment, for those of us who aren't familiar with it, when did it come into play? What did it say? And then how is this yet another assault on it?
Mm-hmm. So we have to put ourselves back in the mindset of the Civil War and what happened after the Civil War. Let's just take for our scenario, Black people are being terrorized in the South. Okay, the Southern states are not yet back in the Union. They have to do certain things to get back, but they have sent federal troops to the South to help protect Black people at this point. The Civil War Congress and the Reconstruction Congress are furiously passing statutes to make sure we can get back to a place where they can enforce laws against the terrorism, essentially. And so they passed civil rights acts to make sure that, the Klan can be prosecuted, for example, the Ku Klux Klan. They passed a series of laws, and at one point they think, the president is going to veto this, so we need to amend the Constitution. The 14th Amendment is passed in 1868. So that amendment has several clauses. One of them is the Equal Protection Clause, basically saying everybody is entitled to equal protection under the law. In that moment, they are specifically thinking about Black people, making sure that Black people are protected in the South, especially. That's not in the text of the amendment, but of course, all amendments are drafted broadly so that you don't need to, include all the specifics in there, and they can expand and be applicable across the eras. So that's the 14th Amendment. We then get to segregated society. Plessy versus Ferguson is the famous case in 1896, where separate but equal is enshrined in law. So Jim Crow is the prevailing way of life for a long time. We get up to the 1950s, Brown versus Board of Education comes out, and that overrules Plessy. Now, in Plessy, one of the justices dissented. This is Justice Harlan. And when you dissent, that means you disagree with the majority opinion. So most people agree that Plessy, which said separate but equal is okay, was one of the worst opinions that any Supreme Court issued in the history of the country. So if you were dissenting, that means you were good. So Justice Harlan is dissenting. He's a white guy back then, so he's thinking in the period of his time, and he's like, the Constitution is colorblind. That's part of his dissent. The Constitution is colorblind. Therefore, separate but equal shouldn't be the law. Well, Justice Thomas today and all the conservative justices, they like to hang their hat on Justice Harlan saying the Constitution is colorblind. Now, that man was just trying to do the right thing back then. And suddenly a whole constitutional movement is based on that. But it's disingenuous. They like to hide behind Plessy. But what they're essentially saying is you shouldn't be able to consider race for anything, not even to help counteract racism. But that doesn't make any sense. Even a child could sit and tell you that doesn't make any sense. It's nonsense. But there's been this concerted effort since Brown to dismantle this notion that you can help people by considering race. you can create benefits to, remedy past discrimination. Now, the reason I'm like Incredible Hulk today is because this has been a long-standing effort, and there's no surprise today. We lost in the 70s with the Bakke case, Regents of the University of California versus Bakke. That was 1978. Yeah. In Bakke, which was not a majority decision, it gets kind of complicated, but there were 6 opinions issued in that decision, which is a totally normal thing, but it basically means that decision doesn't have a lot of weight. In that decision, Justice Powell said, hey, you can't have quotas in university admissions based on race, but also the interest that you can pursue with race-conscious admissions is diversity. It is not remedying past discrimination.
Yeah.
So that was the big loss. Slips under everybody's nose because this is all a big puzzle piece, a big puzzle, and these are just single pieces. But at that point, the court essentially made it illegal for you to do things under the 14th Amendment in order to remedy past discrimination, unless it was like your specific college, you can prove that they discriminated. But we know how discrimination works. You can never prove a specific institution. And what about new institutions that just came into being that are racist? So in that moment, this country decided it was standing in opposition to combating racism, essentially, or even talking about the residual effects of enslavement in this country. And so they went around this diversity thing. Bring it up to 2003, Grutter versus Bollinger, Michigan case. Justice O'Connor writes the opinion. And, she's considered like semi-liberal justice, but we have a lot of critiques for her in that opinion. In that case, they're again thinking about race-conscious admissions. She says, okay, diversity, you can pursue that. The benefits that flow from diversity. Okay, so race-conscious admissions, we can promote diversity. So all the DEI stuff that we know about these days, it sort of evolves from this moment of diversity is legitimate, institutions can pursue it. But she put a ticking time bomb in that opinion. And she said, in 25 years, these measures should not be necessary. We should be in a better place 25 years from now. That's 2003. So 25 years from then is 2028.
Plenty of time.
Plenty of time.
We can turn this around.
Out for you.
We can turn this around.
Right.
5 years.
After hundreds of years, plenty of time. That was arbitrary. It was based on nothing. From the moment she wrote that, people were criticizing it. And today the court said, hey, it's been 20 years.
All right, it's time.
We had 20, so we're good.
Angie Marissa Porter, American U professor, teaches law through an Africana lens. What's the gain? What's the game? You said it's a big puzzle. When all of the pieces are in place, what do we expect to happen? And then how do we combat it?
Well, I'll say in the immediate future, there is this legal result that happened today. And then there's the practical result. Past is prelude. When Grutter came out, everybody, and when I say everybody, I don't mean higher education only. I mean hiring committees, recruiting committees in the private sector. Everybody rallied around Harvard's admissions model as the model, the gold standard for how you evaluate people, essentially. So if you're listening and you've ever sat on a hiring committee, you probably know that. You probably feel that. There's an industry standard to hiring and not being biased and promoting diversity. That really came from that moment. So when folks talk about this decision today impacting culture and society, that's what they mean. They're talking about the practical effect. So this decision, yes, legally applies to higher education institutions, public and private, by the way, higher ed institutions. But as a practical matter, it applies to every hiring committee you're going to see, because they're reading this right now. And folk aren't up there drawing a Venn diagram or trying to, say, oh, does this apply to us? No, they're saying, hey, the Supreme Court said you can't consider race. We don't want a lawsuit, so we're not going to consider race. So what that means is it's a win for the conservatives. It's a win for folks on the right, because they are trying to return to the era before Reconstruction. They're trying to make America great again. So they're trying to go back to pre-Reconstruction, meaning they're trying to go back to a society, like Mike Pence said, that doesn't even think about race. And by that, they mean doesn't think about Black people. Because they think about race.
But Angie, 4 million people had just been freed from enslavement for several hundred years. This ain't that.
No,
this is a whole different. They about to find out. They're in the find out portion. You just made me rub my hands together. Seeing thoughts and prayers.
Yeah, I guess I got a question, and always thoughts and prayers. But how is there a mechanism for the Supreme Court to look at reality, like actual history? I know it sounds funny, but it's like they did that in Brown. They were like, well, obviously there's a clear problem here. And then they kind of found the pathway for it, right? And you would call that, the Constitution being a living document and all that stuff. But
yeah.
But is there another mechanism, legislatively or whatever, that can maybe codify an acknowledgement that can then be based to help close some of these gaps or these injustices that have happened, right? Can we have something that says, like a declaration that says redlining was real, or that the Homestead Act created this many multi-millionaire generationally wealthy people, and because of this we need this piece of legislation?
Yeah, so no.
Yeah, I knew you were going to say. I was like, this is going to be a hard no. This is going to be.
Short answer is no. And okay, there is a mechanism.
All right, Smiz. Thank you, Smiz.
There is a mechanism, and that mechanism failed. So with the judiciary, they are a check and balance on the other branches of government. In this situation, we're looking at purely the Constitution, not laws. So not statutes passed by legislatures. Right. So this is firmly in the realm of the court. Now, the mechanism to get facts in front of the court is the briefing process for these cases and oral argument. In this case, many organizations wrote briefs. The Asian American Legal Defense and Education Fund, the NAACP Legal Defense and Education Fund, which has been working on this. The NAACP been there since this became a topic in legal jurisprudence. Many organizations, Michigan, which was the school at the center of Grutter. And Michigan, after Grutter, passed a law banning affirmative action in Michigan. Michigan was like, don't do this, because in Michigan we did this and our diversity went off a cliff. Minority enrollment dropped precipitously. This will happen. They wrote a brief. These briefs contain all kind of statistics, all kind of scientific data, because, this society and social structure loves science. Court didn't care. So what you've just revealed, Sina, is how subjective all of this legal reasoning is. Yeah. You have the tests, you have the logic, and then once you get to the bottom, this is like algebra. Once you plug in for X, you're just plugging in stuff you feel. It always gets to this point like if you read a legal opinion, it always starts very rote, very analytical. And at the end, you plug in for X. You get to this point where people are just injecting their viewpoints. So it's like logic is masking people's feelings. So yeah, we can't really inject that reality. And just like Sotomayor and Jackson wrote in their dissents, they both wrote dissents today.
When we come back, we're gonna
okay.
Let's break down those dissents. Elie Mystal will be here too, and I want y'all to chapter and verse break down the dissents. But again, it's done. It's done. And so my big question is, where is our Edward Bloom? He lost before, but he didn't quit. He's been on this journey for the last 30 years, right? Fighting. And today he comes out a winner, a man from a certain background who has been fighting this for other people of other backgrounds. I don't know what his agenda is per se, but we used to have that when I brought up Spotswood Robinson and Paulie Murray and Thurgood Marshall. Charles Hamilton Houston. They would be in the lab constantly coming up with the strategy to dismantle racism in the law. I feel like a lot of our legal minds are, taking them good checks and out here chasing ambulances. I said it. All right, 866-801-8255. And then some of them are educating the next generation like you are, Angie.
I run my fingers through her hair as she smiles and says that she loves me. Isn't it lovely when the one you're lusting